I think it's just Chicago and Cook County. I don't think there's one statewide.
Yeah.
Good evening and welcome to tonight's episode of Tenant Thursdays presented by Lawyers Committee for Better Housing. My name is Alan Haley and I am LCBH's Director of Development and Communications. LCBH is a 40-year-old organization that advocates for renters facing unjust evictions and living in substandard housing. When we were formed 40 years ago in the Rogers Park neighborhood by then Alderman David Orr, a group of 10 attorneys volunteered, and each of the attorneys took a building case and helped tenants respond and demand repairs from landlords who were neglecting conditions in the building. That work led to partnerships with other community and tenant advocates, and LCBH and others helped to eventually pass what became the Chicago Residential Landlord Tenant Ordinance. Tonight, we are happy to talk about a similar piece of legislation passing in Cook County. As of June 1st, Cook County now has its own residential tenant landlord ordinance. And with us tonight to talk about why this is important and the particulars of the new RTLO, we have Megan McClung, who is a civil legal clinic attorney, school-based civil legal clinic attorney for the Moran Center for Youth Advocacy. And we have Michelle Gilbert, LCBH's legal director. To begin, Megan, would you please tell our listeners a bit about your work and the Moran Center and your perspective on why the RTLO is so important?
Hi, thanks for having me here as a special guest. Again, my name's Megan McClung. I'm a civil attorney at the Moran Center. And like LCBH, we're a 40-year-old organization. In fact, we're celebrating our 40th year this year. We are historically known for representing the youth in the Evanston community, and specifically young adults in criminal and educational proceedings. In 2018, we started the school-based civil legal clinic in an effort to meet more of the legal needs of families with school-age children. The Moran Center attorneys support low-income families and children attending Evanston Skokie District 65 schools. We provide free legal assistance and advice on civil matters, especially housing rights and representation in evictions. Our goal at the Moran Center Civil Legal Clinic is to address families' housing issues because it impacts a child's ability to stay in or succeed in our schools. Currently, our clinic is remote, just like the courts because of COVID. But if you or someone you know with children attending Evanston Skokie District 65 schools need to contact us for legal help, they can call us at 224-714-0518. Again, that's 224-714-0518. Or they can email clinic@moran-center.org for an appointment. And to answer that question of why is it so important that this Cook County residential tenant landlord ordinance was passed, I can tell you that in Evanston, we are one of 3 municipalities that have our own ordinance that covers and provides a nice layer of protection for tenants. However, it is very apparent because we have students who have addresses both in Evanston and Skokie, that whenever we had families who lived in Skokie come to our clinic, we couldn't help them because there was no laws in Skokie to help tenants who had eviction or other housing issues. And so that's why it was so important for us to make sure that all of Cook County had the same protections that we see here in Evanston as well as Chicago.
Thank you, Megan. Michelle, would you introduce yourself and also add to the perspective of why this new piece of legislation is so important?
So I'm Michelle Gilbert. I'm Legal and Policy Director at Lawyers Committee for Better Housing. And I was very excited to work on the county ordinance. Particular shout out to our partners We had a coalition of tenant advocates throughout the county, lawyers, non-lawyers, community activists. And we're very fortunate to work with Commissioner Scott Britton and Commissioner Kevin Morrison from the North Suburbs, who really were wonderful sponsors to keep all of this moving. And ultimately, after a lot of negotiation, the ordinance passed unanimously. So we thank the whole county board for their support, and we're excited to begin informing tenants of their rights and helping enforce them in court.
And Michelle, you and Megan have a really wonderful PowerPoint tonight to show our viewers, to give them a high-level overview of what's in the RTLO, if you want to start on that.
Well, I want to just start by explaining where the RTLO applies. So it applies everywhere in suburban Cook County except the city of Chicago, Evanston, and Mount Prospect. As Megan explained, Evanston, Chicago, and Mount Prospect have their own comprehensive landlord-tenant ordinances. That's really important, that word comprehensive there. So where the municipality hasn't enacted its own ordinance, it applies. And it's not just unincorporated Cook, it's everywhere else. Most landlord-tenant relationships are going to be covered. There are just a couple of exceptions. It's exciting. It covers also subsidized housing. It covers mobile homes. The limited exceptions for some SROs, some things you might think like convents or college dormitories. It does not cover owner-occupied buildings with 6 or fewer units. Something that's really important in the county ordinance is that if the ordinance doesn't apply, the landlord has to tell the prospective renter. And that's something that we don't have in Chicago. And that's a pretty good idea, because tenants should know when they're going in whether they're going to have these covered rights or not. And there are provisions against lockouts, but that applies to every tenancy. So actually, I'll let Megan talk a little bit about what lockouts are and how the ordinance covers them.
Thanks, Michelle. So where lockouts apply, it's everywhere, Cook County. There's no exceptions, and it provides this added layer of protection. And so the question now is, what happens what is a lockout and what can a tenant do? So what is a lockout? It is really things you might not have thought of if there's a utility shutoff, or if the landlord removes your property. Of course, it definitely applies to changing or adding locks, blocking doors or windows, removing anything necessary for the tenant to live there. But any interference with utilities, water, heat, is considered a lockout. It's considered to be illegal. Also, just the threat of a lockout or using force is also prohibited. So how do you go about requesting repairs is the next issue that we see commonly. So lockouts is probably number one of the big ones, and it's great that the new ordinance covers everywhere. And then what we see in our clinic a lot is how can we get our landlord to make repairs to a sink that's not working, but if there's bug infestations, any type of repairs. What you want to do is make sure that you talk to a legal expert first before you withhold any type of rent. So please take this caution. Don't withhold rent until you talk to an attorney first. You never want to withhold the rent, especially if you're living in subsidized housing. It can be very risky to losing your housing voucher. So let's talk first about requesting non-emergency repairs, and then I'll talk about requesting emergency repairs. So a non-emergency would be if there is a bug infestation, if there is a crack in a ceiling, and if there is a non-emergency repair that you need, what you do is you report it in writing. Make sure that you save what you reported in writing because you may need it to prove something in court later. And then what's very key is you have to give the landlord 14 days to repair something that is non-emergency in nature. So non-emergency repairs, you have options after 14 days. So what if the landlord doesn't do anything? Then you have the ability to withhold from your rent up to $500 or half of the rent, whichever is larger. And just on a side note, in Evanston, it's actually capped at $200. So this ordinance actually expands this added layer of protection for people who are outside of at least Evanston. And Michelle, maybe you can chime in on what it is in Chicago.
I think it's the same, this $500 or half the rent, whichever is larger. And I'm
That's
happy
right.
to say that we are working with the City of Evanston government about changing the Evanston ordinance to make it comply with the same provisions as in Cook County.
Excellent. Yeah, it'd be great to have it be more universal. So at this time, $500, but this is why you should really contact somebody who is an attorney or a legal aid attorney. And it's why a suburban office like the Moran Center it's really key to contact us because we know the Evanston ordinance and what your rights are. So if you're going to withhold rent, you have to give 14-day notice wherever you are in Cook County. And then it is a question of how much do you deduct depending on where you live. And make sure you save receipts of whatever you spend it on for the repairs. And if the landlord doesn't do anything and you decide you don't want to spend money on it, maybe the cost is greater, it's prohibitive to do it, you can decide to leave in 30 days and terminate the lease. That is another option. So let's talk about requesting emergency repairs. Emergency repairs are anything essential: water, heat, major plumbing issues, gas, electricity, and in some leases, it could qualify lack of internet, especially during COVID times, right? So if there is an emergency repair, again, you have to give the notice in writing, and you have to give the landlord 24 hours to address the emergency nature. So emergency repairs, if it's not done by the landlord within the 24 hours that you provide in written notice, then you can go ahead, similar to the non-emergency, make the repair yourself, save the receipt, deduct the cost from your next month's rent. There's some other things that you can do if the repair's more than 500 or half the rent. So again, the best thing to do is contact an attorney, a legal aid attorney, if you need emergency repairs and the costs are more than $500 or half your rent. So again, talk to a legal expert. Lawyers Committee for Better Housing has a rentervention. I'll let Michelle talk more about that. It's a great place to go and ask questions, find legal forms, do some self-help before you find any issues with your landlord giving you problems back. So just make sure that if you are subsidized housing, you never ever want to withhold rent until you talk to an attorney.
So thank you, Megan, for mentioning rentervention. Anyone who looks at our Tenant Thursdays has heard us talk about this service. Maybe you just want to get some more information. You're not ready to withhold, or you're not ready to talk, make an appointment to talk to an attorney, but rentervention is a great way to, you can ask questions. It is right now in the process of adding all of this information about the county ordinances. So you'll be able to just put in your zip code and it will know what law applies. And in addition to giving you some information, it also can help you generate letters, like the 14-day letter. Because Megan and I can't emphasize enough, if you're going to do any withholding, put it in writing, keep copies of everything. Because, if you get so far that you're in court, we hope that it doesn't, but if it does, you want to be able to have that paperwork to hand up to a judge. So there are a couple of other provisions about the ordinance that are really important. Probably my favorite is that, like the city of Chicago, under the county ordinance, all tenants have a one-time right to pay the amount of rent that it's due, plus court costs, but not attorney's fees. And even if the landlord has filed a court case, as long as the judge has not entered a judgment against the tenant can pay and stay. And that is really huge, especially now in COVID. People accessing rental assistance can get cases that are filed against them dismissed. Without the ordinance, a tenant could try to pay on the 10th day, the landlord could refuse the money, or the landlord could take the money and then still go ahead with the eviction case. But no more. Now tenants throughout Cook County really have the right to pay to stay. And I'm just going to touch on a couple of other changes, especially things that are a little bit different. If you live in Chicago, you know that landlords have been changing around security deposits and calling them move-in fees. So county ordinance is great. It says, landlord, sure, you can charge a move-in fee, but it must be reasonably related to your expense. No more pull $800 number out of the air and charge it as a move-in fee. If you really do have to pay for security or whatever a landlord might have to pay for to let you move into the property, yes, the landlord can pass that through, but can't make it a profit center and can't make it a way to avoid the security deposit requirements. Again, huge change that I'm really happy the county made. Security deposits can only be 1.5 times rent. I was recently working with a tenant who's trying to move, who ended up between paying first month's rent and a ridiculous, almost like 3 times security deposit, and to move into a place in the suburbs. And that was back in May, and that is not allowed anymore. Security deposits cannot exceed 1.5 times rent. They have to be returned just like under the Chicago ordinance, but the landlord doesn't have to pay interest on the security deposit any longer. Kind of a change to get something that tenants gave up, but instead got these important protections for the limit on the amount of security deposits and on the excessive move-in fees. And there are other protections, again, let me say that we picked out a couple of slides for highlights, but Megan and I and lots of other partners, Legal Aid Chicago, Housing Action Illinois, have put together a whole slide presentation, and we are happy to talk to community organizers and give information. Any community groups out in the suburbs can do much longer presentation on the county ordinance. And if you're interested, you can comment on Facebook and Ellen will get the information to us. And I think a couple of other protections that the ordinance protects against retaliation. So always scary for tenants to try to enforce these other rights, but landlords can't try to charge you more money or try to evict you if you stand up for your rights. Oh, and like I said, there are provisions that cannot be included in leases including, very important to me, the excessive late fees, which I saw a lot in the suburbs. Those are outlawed under the ordinance. So I'm gonna leave up this slide for people to get this information. If you have, questions about the ordinance, you can call or go to the website of one of these organizations that represent tenants out in the suburbs, or like I said, our Rentervention is a place to get legal information and to help develop the letters and notices that you need to use to implement the ordinance.
I have a question. I think it was Megan that you mentioned on one of the slides that a landlord has to notify a tenant if the unit that they're living in isn't covered by the RTLO. But I'm just curious if there's the flip side of that, is there any requirement in terms of landlords notifying tenants that the RTLO now exists? I mean, I realize it's only new as of June 1st, but how do I know that I have these new protections if I'm a renter in Cook County?
Michelle, can you help with that one?
Oh, well, so I will say it's one of the reasons that we're doing this community legal education effort to advise tenants of their legal rights. And there's a lot of information on the Cook County website. And I know the commissioners, I know Board President Freckwinkle have been doing community legal education events as well to get out the word about the ordinance. So for example, there is an official summary of all of the rights and responsibilities in the ordinance that's available on the website, that's available in English, Spanish, and Polish. And Alan can put the link to that in the chat. In terms of going forward, knowing that the tenancy is protected, the landlord has to, when the landlord enters into a new lease, the landlord has to attach a copy of the summary to the ordinance, to the lease. And even if they don't have a written lease, the landlord has to give someone a copy of the summary. So that, if somebody has a lease that they entered into in February, they might not be getting it right away because, the requirement doesn't kick in until they have a new lease. But they should be getting a copy from the landlord, not a copy of the whole ordinance, just a copy of the summary when they enter into a new lease.
So going on that question a little bit further, so in Evanston, Mount Prospect, Chicago, do all landlords have to provide that this doesn't apply since there is a comprehensive ordinance that does?
I know in Chicago, landlords have to attach a summary, and there's an official summary, like probably on the Department of Housing website, that landlords have to provide people. I don't actually know in Evanston and Mount Prospect. I have a wonderful chart compiled by one of our astounding interns, but I don't have it. I don't know if that's a provision in the Evanston and Mount Prospect ordinances.
Yeah, I'm at least in Evanston, the ordinance does not have to be provided with the lease. But I still have that question of then, do they have to provide that the Cook County does not apply? I guess that's something we'll need to ponder at our next meeting.
Right, probably they don't, but you're right. I think it's a good question, and I think we tried to answer a lot of questions in the document, but obviously some questions remain. But I'm really excited about this Evanston effort to make sure that their ordinance has the same provisions like the protections on late fees, the move-in fees. And so I think probably we'll be talking on Tenant Thursday sometime, maybe later this summer, maybe in the fall, about what changes we need to see to the Chicago ordinance. Some of the things that I would say modernize the Chicago ordinance, and also so that it includes advances that are in the Cook County ordinance.
I think I know the answer to this question, but I'm going to ask it anyway. You said, I believe, Michelle, that if somebody were to sign a lease, if I understood right, after June 1st, that the landlord needs to provide a summary, attach a summary going forward. But if I signed a lease in February, I am still protected now that this has passed. I just won't get the summary, or am I not covered until my current lease ends?
There is one section that applies to leases and provisions that they either must contain or they are prohibited from containing. And that section doesn't apply to the tenancy until there is a new lease. And it just was kind of a balance issue of not requiring every suburban landlord to enter into a new lease that was effective June 1. So that particular section doesn't apply, but the rest of the protections in the ordinance do apply. So like the rent withholding, the retaliation protection, those apply. Just this one section that's about, that really is about the language of leases doesn't apply until there's a new lease. And, and I use lease a lot, but I want to make sure that people know that when I say lease, it's actually defined in the ordinance as an oral or written agreement. So if you are, and that's true in Chicago or suburban code. So if you, you just moved in and you just are month to month, then these protections still protect you. It's not just folks who have leases, because leases also means oral agreement. It's a little confusing the way that it's worded, but lease means oral or written.
So 2 weeks ago, our Tenant Thursday topic was about rental assistance, and we had Tom Benedetto, who's the director of policy and government affairs for the Chicago Land Apartment Association. That was a really great session, having a landlord perspective. I'm curious, Michelle or Megan, are there any things that maybe weren't covered in your slide that speak to landlord protections under the RTLO?
There are definitely those protections in the RTLO. Like I said, I skipped out and tried to just get like the biggest high interest topics for this slide. There are provisions for landlords about adopting rules and regulations. So landlords can include terms in their leases, or they can have, house rules or regulations. There's also a section on tenant responsibilities. There are also some provisions if the tenant can't withhold rent to fix something that the tenant broke. So, usually things that break are just kind of wear and tear. The heat goes out, the electric goes out, stuff gets old. But if the tenant, say, I don't know, smashed in the door, the tenant can't withhold rent to fix the door. So, I would call that a landlord protection. It's why there are a lot of nuance, and that's why both of us said many times, talk to an attorney.
Well, I think, are there any final comments or pieces of recommendation for tenants as we as this new ordinance starts to take effect?
I think, you know, for me, like the final word would be a lot of details here, but we're happy to do community legal education and speak to groups. And if you're interested in something like that, you know, put it in Facebook and Alan will get it to us. And, you know, we have people who are trained to make these presentations.
And then I just have to say, Lawyers Committee for Better Housing was the driving force behind getting this Cook County residential tenant-landlord ordinance written, rewritten, drafted, talking to everybody. And it was the leader of that group was Michelle. So I'm just, I was a passenger and she was driving it the whole time and did a lot of work on this.
Well, that's really sweet to say. Of course, you know, it's really all about the board and the commissioners. And it was a good experience. It was a very good negotiated experience. Things that we gave up that we didn't want to, things that ended up in there that the landlord side didn't want, but very constructive engagement. You know, I have to thank the commissioners, all of them, our sponsors, and all of the commissioners that worked on it. Just a really high level, you know, Congress could learn from the Cook County Board.
Great. Well, thank you for those compliments, Megan, and thank you for being a guest tonight, and Michelle for all your work on the ordinance and the work you do for LCBH's clients. With that, we will wrap tonight's Tenant Thursday. Next week, we will be back on June 17th, and our topic in recognition of Pride Month will have to do with fair housing as it impacts the LGBTQ community. So we hope to see you then. So with that, have a good night, Megan and Michelle. Great to see you.
Thank you. Thank you, Megan.